Any of the parties present? Can counsel hear me, please? Can counsel hear me?
Yes, my lord.
Yes,
I
my
can
lord.
hear you, my lord.
Counsel can hear me.
Yes, my lord.
Parties, no parties present. Any party present? Appearance. Appearance.
My lord, counsel for the claimant is still connecting to audio.
Appearance for the claimant. Can I take your appearance, please? Mr. Fashusi, can you hear me? Can all counsel hear me?
Yes, my lord.
Yes, my lord.
I see that the parties are still, the claimant is present. Claimant's counsel is still trying to connect. Who is what about the technical?
My lord, the first counsel is here.
Any one of them, so that they can. Are parties present, please?
It appears the claimant is present, my lord.
I can see a name, Itodo. Appearance, please. It appears as if we're having a problem with connection. Appearance, can counsel hear me, please? Can I take your appearance?
My lord, I can hear you. That's counsel for the defendant. I don't know if I can announce my appearance since counsel for the claimant appears to have some technical challenges.
Counsel for the claimant, can you hear me? Claimant's counsel? Claimant's counsel, can you hear me? Good morning. I want to know what is happening. Some can hear me, some cannot hear me. Yes. I can't hear the claimant's counsel. That's the fascist. He's there, I can see him, but I can't hear him. I can't hear him. On here, yes. What about this person is that fascist? Is he muted?
The council is present, but they can't hear you, man.
We are trying to make sure that everybody hears us and that we can hear everybody as well. Claimants Council, can you hear me? Claimants Council, can you hear me? Defendants Council, you can hear me. Can you still hear me? Defense Council, can you still hear me?
Yes, my lord. Yes, my lord, I can hear you very clearly.
Can you hear me, Registrar?
Yes, my lord, I can hear you clearly.
Miss Echo, can you hear me?
Yes, my lord, I can hear you clearly.
Okay, Mr. Fatusi, can you hear me? Ayotunde Shabi, can you hear me?
Yes, my lord, I can hear you clearly.
My lord, Ms. Ayotunde Shabi and I are appearing for the defendants. So the defense counsel is still inaudible. He has sent a message, my lord, that he cannot hear anything.
Yes, we will. We are trying to, we'll do something about it. Just what if you sent him a message? Mr. Fatusi is the problem must be from his own end. The problem must be from his own end, his own connection. Can everybody else hear me, please? Can everybody else hear me? The parties who are present, can the parties hear me?
Yes, my lord.
Yes, my lord.
And counsel
Yes,
can
my
hear my
lord.
lord. Defendants counsel can hear my lord.
Sorry? Well, I have to start. I will take appearances. Mr. Dedi Fatusi, I can see him. I will record him as appearing for the claimants.
Scott pleases.
Yes, Defense Counsel.
May you please?
Technician, we shouldn't run the way in case we have any other technical problems. Yes, appearance please for Defense Counsel.
May it please your lordship, L.O. Ikwagu, Mrs. My lord, I appear for the defendant. And with me is my learned friend, Ms. Ayotunde Shabi.
In reading the judgment, I shall simply read the claims and I will go straight to the decision section. I hope counsel can hear me.
As the court pleases.
Yes, my lord, as court pleases.
Mr. Fashosi, can you hear me? Okay, please.
My lord, in view of the fact that a recording of the meeting of these proceedings are being held, may I suggest perhaps that a recording be sent to him after the meeting, after the court session?
It's a standard procedure.
As court pleases.
Standard procedure.
As court pleases.
But I must ensure that
I can hear my lord very clearly.
You can hear me now.
I can hear my lord clearly. Yes, my lord.
Right.
I'm grateful for the indulgence. I can hear my lord.
Courts to ensure everybody has the opportunity to hear the proceedings, except where it's simply impossible. So the court will always spend some time to ensure that all counsel and everybody can hear. But then we'll, but he has said now that he can hear. Yes.
I can hear my lord. I'm not being.
The prayers, and then I will go straight to the judgment section. The claimant filed this complaint against the defendant on 4th October 2016, seeking the following reliefs. A declaration that the determination of the employment of the claimant in the defendant by a letter of dismissal dated the 20th of February 2014 is tainted with bias, as same was done in persecution of the claimant on account of his trade union activities with the Association of Senior Staff of Banks, Insurance, and Other Financial Institutions, (ASBP), in the defendant's unit, and is therefore unlawful, unconstitutional, null and void, and of no effect whatsoever. B, a declaration that it is unfair labor practice for the defendant to dismiss the claimant on account of the claimant's protest over the wrongful termination of workers in the defendant who are members of the claimant's union in the defendant's unit, without recourse to the laid down procedure in the collective bargaining agreement between the defendant and the Association of Senior Staff of Banks, Insurance, and Other Financial Institutions, (ASBP). Thus, the said letter of dismissal dated 20th of February 2014 is consequently unlawful, null and void, and of no effect whatsoever. C, an order directing the defendant to reinstate the claimant to his post in the defendant forthwith without any loss as to seniority, salaries, position, and other emoluments. D, an order directing the defendant to compute and pay to the claimant all his salaries, allowances, and other emoluments due to him specifically for the month of June 2012, when the claimant was suspended, to the month of February 2014, when the claimant was dismissed from the services of the defendant. Alternatively, an order that the letter of dismissal dated the 20th of February 2014 be converted to letter of termination of the claimant's employment in the defendant, thereby entitling the claimant to all shares from June 2012, when he was suspended from work and placed on half salary, to February 2014, when he was wrongfully and unlawfully dismissed from service of the defendant, gratuity, 13-month salaries for the years 2012, 2013, and 2014 respectively, leave allowances for the years 2012, 2013, and 2014 respectively, and 1 month salary in lieu of notice and other emoluments. F, an order for interest at the prevailing commercial bank's rate on the sum arrived at in relief D or E above respectively. Accompanying the complaint is the statement of facts, claimant statement on oath and copies of documents. The defendant filed the statement of defense and accompanying processes on the 30th of January 2017. The claimant filed a reply on the 9th of March 2017. I shall go straight to the decision section now. Everything is contained in the judgment, the body of the judgment. All submissions, the final address are all considered, are all included in the judgment. Decision. I have finally considered all the processes filed. the oral and documentary evidence led, the final addresses, authorities, and arguments canvassed therein by counsel. I will begin with the preliminary issue raised by learned defense counsel in paragraph 2.1.10 of the reply on point of law, where it stated that the claimant's final address failed to properly reply the issues raised in the defendant's final address and are deemed to have been considered by the claimant. Defense counsel fails to identify those issues in which a proper reply was not given. It is the duty of the court to determine whether a proper reply to an issue has been made. I have looked at the claimant's address and am satisfied all the relevant issues have been properly addressed and no issue has been considered by the claimant. The claimant testified that the staff of the defendant were organized in 2009 as a branch unit of the Association of Senior Staff of Banks, Insurance and Other Financial Institutions as BP, and his election as deputy president and subsequently branch president was witnessed by the defendant, who was supportive of the union. The defendant denies this, and the evidence of DW in paragraph 6 of the deposition is that ASPP does not have the support or approval of the defendant. The defendant also states that it is not a financial institution, but is registered by the Securities and Exchange Commission to conduct share registration business. In my considered view, the three issues that arise for determination are therefore as follows. One, whether the defendant is a financial institution whose employees should be organized or unionized by ASPP. Two, whether the claimant was prosecuted as a result of his trade union activities with the Association of Senior Bank of Staff, Insurance and Other Financial Institutions, ASPP. Three, whether the defendant justified the reason it disengaged the claimant from its services. In order to ascertain whether the defendant is a financial institution, there is the need to look at the scope of the trade unions provided for under the third schedule to the Trade Unions Act 2004 to cater for the financial sector. ASPP is the trade union for senior staff, while National Union of Banks, Insurance and Financial Institutions Employees, NUBIFE, is the trade union for junior staff in the financial sector. NEBA is the umbrella and counterpart trade union body for the employers in the financial sector. To understand the jurisdictional scope of these trade unions, it is to NUBIFE we must go. Under item 7 of part B of the third schedule to the Trade Unions Act, the jurisdictional scope of NUBIFE is as follows, and I quote: workers in banks and closely related institutions, such as mortgage companies, industrial loan institutions, agricultural credit agencies, cooperative credit societies, investment companies, holding companies, insurance carriers of all kinds, insurance agents and brokers, organizations serving insurance earners, consultants for policyholders, adjusting agencies, other closely related institutions not otherwise mentioned, all types of dealers in real estate. At this juncture, I will refer to and reproduce the relevant part of the recent decision of this court delivered by the President, Honorable Justice B.B. Kanib, in Adesonya Adeyemi Joachim versus Union Registrars. Judgment delivered 17 December 2019, where the status of the defendant was settled. And I quote: the point to note here is that NUBIFE, as BP and NEBA are trade unions meant to cater for the financial sector. This court has long recognized that the design of trade unions based on the 1978 restructuring exercise was fashioned according to industry, and so can be said to be industry-based, with the senior staff and employers associations following after the industrial unions, made up of essential engineer staff. Sea Air Transport Services Senior Staff Association of Nigeria versus Senior Staff Association of Statutory Corporations and Government-Owned Companies. And Precision Electrical and Related Equipment Senior Staff Association versus Senior Staff Association of Statutory Corporations and Government-Owned Companies. In determining the jurisdictional scope of these trade unions, the key phrase is workers in banks and closely related institutions. The types of related institutions are then mentioned, prefaced by the words, such as. This means that the list is not exhaustive. This is followed by the phrase other closely related institutions not otherwise mentioned. The question which presently arises is whether a company registered by Securities and Exchange Commission to conduct share registration business is not in the financial sector. It's not in the financial sector as to be deemed a member of NIABA. I am of the firm belief that it is, and I so find and hold. This being so, the argument of the defendant that it is not a financial institution is lame and unsustainable. I reject it and so will discountenance it. The defendant is a financial institution within the context of the jurisdictional scope of the trade unions set up to cater for the financial industry. As such, having to be a signatory to Exhibit C10 before it can be bound by it is not a requirement, and the claimant is not thereby required to prove the defendant's membership of NIBAD, that being assumed in virtue of the defendant being a financial institution. If the defendant chose not to participate in the activities of NIBAD, that is its concern, but that has nothing to do with its deemed membership of the association. I so find and I so hold. End of quotes. The defendant has not given me any reason to depart from the reasoning in this decision, premised on the 1978 restructuring of the trade unions according to industry and the Trade Unions Act, that is the primary legislation. The decision in Adeleye, Mary Arit, and 39 others versus Asbifi, Supra, relied upon by Learned Defense Counsel in paragraphs 2.1.3 of the reply on point of law did not consider the 1978 restructuring of the trade unions according to industry and the Trade Unions Act. Moreover, Adesonya Adeyemi Joachim versus Union Registrar Supra is a later decision of this court. I hold that the defendant is a financial institution within the context of the jurisdictional scope of the trade unions set up to cater for the financial industry. And ASBP is the association with the jurisdictional scope to organize, unionize the defendant's senior staff. The claimant has placed before the court his offer of employment, Exhibit C1, letter of confirmation, Exhibit C2, staff handbook, C4, C14, service agreement, Exhibit M11, query and reply, Exhibit C11 and C12, letter of suspension, Exhibit C13, letter of dismissal, Exhibit C10, letter of appeal, Exhibit C15, and correspondence between ASPP and the defendant. I hold that the claimant's offer of employment, the service agreement, and the defendant's staff handbook together make up the claimant's contract of employment. The claimant has testified that he was persecuted by the defendant for his trade union activities and subsequently dismissed for his trade union activities. Now, what is the evidence? I find that there was in existence in the defendant from year 2009 a branch unit of ASPP, and the claimant was the president. I also find from the documentary evidence that the defendant exchanged correspondence with both the branch unit and the national body on different occasions, granting requests from the union for release of its members for trade union activities, as seen in Exhibit C16, C18, C19. It is therefore not correct that the defendant did not support or approve the union. The defendant admitted that it received a letter from ASPP dated June 16, 2011, signed by the claimant in respect of the termination of appointment of 6 members of the union, in which he drew management attention to the provisions in the collective agreement. The claimant testifies that it was after this letter his persecution by the defendant began. By a letter dated 13 July 2011, Exhibit C4, the defendant redeployed the claimant to his Owerri branch to report for duty on July 27, 2011, which the claimant has alleged to be a punitive transfer, and that before the transfer notice took effect, the defendant had demobilized his password to the workstation. The defendant denies that the transfer was punitive and that the employment contract makes provision for transfer. Generally, an employee is not to determine where he is to work, and transfers may be justified, but in appropriate cases, transfers may be unjustified, and the law frowns on such, especially where they are punitive or malafide, as where the transfer is to prevent trade union activities, disrupt trade union activities, or a punishment for trade union activities, or to harass the employee. See generally chapter 3 on unjustified transfers of HL Claimant's transfer of employees under labor laws, Universal Publishing Company Limited. The claimant wrote the defendant by Exhibit C5 on July 20, 2011, referring to the provisions of the collective agreement between Nearby and ASBP. The collective agreement, however, is not before the courts. The question is whether the claimant has made a case of unjustified punitive transfer in complaints of. The uncontroverted evidence is that at the time the claimant's password was disabled, his transfer had not taken effect. This amounts to a lockout of the claimant. The defendant reversed the transfer and redeployed the claimant by Exhibit C6 to Investor Relations Department with effect from 17th October 2011. This decision was taken after the intervention of the national leadership of ASBP. I find this to be an indication that the claimant's transfer to Owerri was a punitive measure by the defendant. There is no evidence to show that the defendant reversed the transfer due to threats of the claimant and the union to embark on industrial action. I believe the claimant's evidence that in 2013, the defendant tried to frustrate the activities of the union by denying its status as a financial institution, issuing a memo to Exhibit C21 to staff to that effect, and threatening them if they attend union activities with termination permit. I find that the defendant's hostility to union activities and intolerance to the person of the claimant is evidenced. Originating summons filed, suit number LAS-28-2014 on January 28, 2014, in which it joins the claimant as a defendant. Answers the questions whether it is a financial institution and whether its staff are eligible to be members of.
No, they say they should call the Chinese National. They should come and remove the potty. Go and wash it. So that you know that they cannot do that.
Background mute themselves. They are disrupting.
Come along with somebody.
The activity.
That's who we can ask. They don't want to be able to.
We are not going to do that. Okay, we don't already do. Because you can stay away.
Can the council hear me, please? Council hear me?
Yes, my lord, I can hear
Yes,
you.
my lord. Yes, my lord.
The defendant has stated Defendant has stated that the subject matter in suit number NICN-LA-28-2014 and its pendency has nothing to do with its right to determine the claimant's contract of service, as there is no nexus between the issues. It is clear that there was internal disputing of the defendant's recognition of the union vis-a-vis its legal status as a financial institution, and staff were being threatened in continuing membership of the union that resulted in the defendant instituting suit number NICN-LA-28-2014, which was struck out. The refusal of an employer to accord recognition to a trade union is a valid ground for a trade dispute. More so, an unfair labor practice is when an employer carries out acts that do not conform to best practice in labor circles, as may be enjoyed by local and international experience. See section 9, 6A and B of the Labor Act. See also Mix and Bake Flour Mill Industries Limited versus National Union of Food, Beverages and Tobacco Employees. The defendants dismissed the claimant on 20th of February 2014. The claimant has alleged bias and asserts that his dismissal was on grounds of his trade union activities. The letter of dismissal states, "You are hereby dismissed from the employment of Union Registrars Limited with immediate effect for gross misconduct." The reason given by the defendant is gross misconduct. The law imposes on the defendant a duty to establish the reason to the satisfaction of the courts. See Olatunbosun versus NISA Council. The defendant, through its witness, testified that the claimant was issued a query for his lack of diligence and misconduct in relation to a series of transactions in the performance of his duty. The claimant admits that he received a query from the defendant on 7th May 2012 in respect of his role in processing dividend warrants that were fraudulently cleared, and he responded to the query by Exhibit C12. He was invited by the head of Internal Audit, Control and Compliance and given a tabulated form of all the issues in the query and asked to respond, which he did. The defendant has raised the issue whether the claimant's reply to the query is an admission of fraud, gross misconduct by the claimant. I find that the claimant's reply was not an admission of fraud or gross misconduct. If it were an admission, there would have been no need for the defendant to place him on suspension for purposes of investigation. The defendant, by Exhibit C13, placed the claimant on suspension with effect from 19th June 2012 until conclusion of investigation. The claimant testified that he was suspended for a period exceeding 3 months, contrary to the staff handbook, and that the defendant reported the matter to the EFCC, who investigated and also invited him for interrogation. His uncontroverted evidence is that there is no report by the EFCC indicting him in the clearing of the dividend warrants. Clause 7.5 of the staff handbook makes provision for suspension as follows, and I quote, "If any employee is suspected of dishonesty or any other serious misconduct, he will be suspended from duty for a period not exceeding 3 months, during which investigations are concluded. During the period of suspension, the employee shall, provided he or she complies fully with conditions stipulated in C below, be paid half of his or her basic salary and full transport, housing and utility allowances, and he or she shall be entitled to usual medical treatment. If after investigation he is exonerated, he shall be recalled and the balance of his or her basic salary and any other entitlements due to him or her shall be made good to him or her from the date of suspension. If, however, the employee is found guilty, he or she shall be dealt with in accordance with the appropriate section of the disciplinary procedures. If the policies suspect an employee of a criminal offense, he or she may be suspended and paid half of his or her basic salary and his or her full transport housing and utility allowances from the date of suspension up to a maximum period of 12 months. If he or she is exonerated within those 12 months, he or she shall be recalled, and the balance of his or her basic salary and any other entitlements due to him or her will be made good to him or her from the date of this suspension. If, however, the case has not been disposed of, he or she shall be dealt with in accordance with the disciplinary procedure. The first paragraph stipulates suspension for a period not exceeding 3 months, while paragraph 3 provides for a maximum period of 12 months on suspicion of a criminal offense. The report to the EFCC indicates that the defendant suspected the claimant of a criminal offense. There is no provision for a period of suspension in excess of 12 months. The defendant was therefore wrong to have placed the claimant on indefinite suspension from 19 June 2012 to 20th February 2014, a period of about 20 months. This is particularly so because the report of the investigation by the head of internal audit, control and compliance, and the disciplinary committee report were ready within the 3 months period, specifically on the 5th of June 2012 and 14th June 2012, respectively. There is no report from the EFCC. An employee cannot be kept under suspension indefinitely because it puts the employee to undue hardship and distress. This court has held in several cases that the suspension of an employee is a disciplinary matter and the disciplinary process must be concluded as soon as investigations are completed. See Mrs. Dayo Boluro versus the Nigerian Institute of Public Relations Practitioners. The report of the investigation by the head of internal audit, control and compliance found the claimant to be negligent in processing the dividend warrants and recommended that he be given a warning letter. The disciplinary committee in its report observed that the claimant was negligent and made the following recommendation, and I quote, "In view of the fraud displayed by Mr. Itodo Monde, which is a gross misconduct, he should be suspended pending determination of the outcome of investigation by security agencies. All the policies enshrined in the staff handbook shall be adhered to accordingly." End of quote. The disciplinary committee did not prove fraud, which is a criminal offense. Rather, it made the recommendation to suspend pending the determination of the outcome of investigation by security agencies, and that all the policies in the handbook should be adhered to. The outcome of investigation by the EFCC is not before the court. DW testified that he was not aware of any report recommending the dismissal of the claimant. I find that what is established by the two reports is the fact that the claimant was negligent in the performance of his duties. And this is not classified as gross misconduct that could result in dismissal in clause 7.7a I to X of the defendant's handbook. By the provisions of clause 7.63 of the handbook, and I quote, "Neglecting to perform any work which it was his or her duty to have performed, or carelessly or improperly performing any work which was his or her duty to have performed carefully and properly," end of quote, attracts the sanction of termination of contracts and not summary dismissal, and I so hold. The claimant has asked for declaratory orders and an order of reinstatement. While there is no doubt that the claimant suffered persecution from the defendant on grounds of his trade union activities, the defendant has been able to establish that the claimant's disengagement was not on grounds of his trade union activities. Rather, the defendant was dissatisfied with the claimant's job performance, and this led to his disengagement. Consequently, the main claim for declaratory reliefs and consequential orders sought in prayers A, B, C, D must fail. They are hereby refused. I must at this juncture state that being an executive of a trade union should not be an excuse or a reason for negligence in the performance of official duties assigned by the employer. Rather, it is expected that an executive of a trade union will be diligent and above board in the performance of his duties. I now come to the claimant's alternative claim that the letter of dismissal be converted to termination. I have already held that the sanction for negligence in the defendant's handbook is termination of contract and not summary dismissal. Consequently, the letter of dismissal dated 20th February 2014 is hereby set aside. The defendant is ordered to issue the claimant a letter of termination of employment and correct the claimant's record in this regard accordingly. The claimant has asked for all his salaries, allowances, and terminal benefits from the date of his suspension up till the date of his disengagement. The defendant ought to have concluded the claimant's disciplinary matter by 18th of June 2013, as suspension cannot exceed 12 months. Having failed to do so, the claimant remained in its employment until 20th February 2014. The claimant is therefore entitled to his full salary and all allowances from June 2013 to February 2014. Salary in lieu of notice and terminal benefits, if any. The defendant is ordered to pay all of these to the claimant within 30 days. The claim for interest at the prevailing commercial rate on the sum arrived at is refused, as there are no pleadings or figures in this regard. For the avoidance of doubt, I hereby state and make the following orders. 1. The defendant is a financial institution within the context of the jurisdictional scope of the trade unions set up to cater for the financial industry. 2. ASBIFI is the association with the jurisdictional scope to organize or unionize the defendant's senior staff. 3. The disengagement of the claimant was not as a result of his trade union activities with ASBIFI. 4. The letter of dismissal dated 20th February 2014 issued by the defendant to the claimant is hereby set aside. 5. The defendant is ordered to issue the claimant a letter of termination of employment and correct the claimant's record. 6. The defendant is ordered to pay the claimant his full salary and allowances from June 2013 to February 2014, salary in lieu of notice and terminal benefits, if any, within 30 days. 7. Each party is to bear its own costs. Judgment is entered accordingly.
As the court pleases.
As the court pleases. My Lord, we thank the court for a most well-considered judgment.
Yes, I think so. The court rise.